Professor Collett, this bill only has an exception for an abortion that is, quote, necessary to save the life of the minor because her life was endangered by a physical disorder, physical injury, or physical illness, including a life-endangering physical condition caused by or arising from the pregnancy itself, close quote. Does this exception comply with the constitutional mandate that you have to permit an abortion when necessary for the life or health of the mother? And to the extent that a woman might need a medical treatment that is inconsistent with pregnancy, she needs a medical treatment that is inconsistent with pregnancy, but is not caused or arising from the pregnancy itself, wouldn't the Constitution require that an abortion be permitted in that case as well, contrary to this bill, rather?
Congressman Nadler, in fact, I believe the constitutional case that you're relying on is Doe versus Bolton, which was a statutory construction case. It was not an interpretation of the Constitution. It was an interpretation of the
Excuse me, there is not a constitutional requirement under applicable Supreme Court law that abortions be allowed for the life or health of the mother?
I'm sorry, Congressman Nadler, if I could complete my answer. In Doe versus Bolton, where they gave the life or health of the mother language, it was statutory construction. In Planned Parenthood versus Casey, which was an opinion that occurred 20 years later, in fact, they upheld an emergency exception remarkably similar to this on a constitutional basis where the language did not have the health of the mother. In Ayotte versus Planned Parenthood of Northern New England, the most recent United States Supreme Court case dealing with parental involvement laws, the court in fact even upheld the statute at issue in that case without an emergency exception. I believe this is completely constitutional, consistent with Planned Parenthood versus Casey and Ayotte.